Hello, on behalf of Tyr LLP, I'd like to welcome everyone to our webinar today about class actions in Canada. I'm joined today by two of my partners, Sean Campbell and Carlos Sao. Unfortunately, Jim Bunting was unable to make it. We're going to do things a little bit differently today in terms of the webinar. We have about a 30-minute presentation where you're going to learn a little bit about class actions and some of the top trending issues in class actions in Canada. I'm going to give a brief summary of the people who you're going to be seeing on screen shortly. So while Jim Bunting isn't here, you will see, he'll be the first that you see on screen. So Jim is a founding partner of Tyr. He's known for his bold approach as a trial lawyer and represents clients on some of the most challenging issues in Canadian litigation. He is recognized as a top litigator in Canada. He has led landmark trials and arbitrations both internationally and within Canada. He is highly regarded for his ability to solve complex problems both in and outside of the courtroom. Jim has deep experience in wide ranges of litigation, including corporate commercial, appeals, class actions, securities, constitutional challenges, and sports-related litigation. He is consistently named as one of Canada's leading litigators by legal directories. Now, the second person you're going to see in our video and that you see on the screen today is Sean Campbell. Sean is also a founding partner of Tyr LLP and is known as an experienced trial lawyer, known for his innovative and enterprising approach to cases. Prior to founding Tyr, Sean was a senior partner at Davies, Ward, Phillips, and Weinberg in the litigation, financials, restructuring, and insolvency practices. Clients in diverse sectors choose Sean to advise on commercial litigation, securities and class action litigation, shareholder disputes, and competition matters. They appreciate his practical and creative approach to high-stakes, multi-jurisdictional litigation. Sean represents clients of all sizes on matters before the OSC's Capital Markets Tribunal, the Competition Tribunal, and all levels of court in Canada. Sean has represented some of Canada's largest companies in the telecommunications, mining, and energy sectors in both court and arbitration proceedings under both international and domestic arbitral regimes. Moving on to my partner, Carlos Sao. Carlos is a partner at Tyr where he practices civil and commercial litigation with a focus on class actions and sports-related disputes. Carlos has significant experience litigating in all levels of court in Ontario and is regularly involved in arbitrations and administrative proceedings. He is counsel on a number of complex class actions representing defendants. In addition to his complex commercial and class action practice, Carlos has significant experience with sports-related disputes. And finally, coming to myself, my name is Pinta McGuire. I'm also a partner at Tyr. I have broad civil and commercial litigation experience. I head up the firm's medical negligence group. I have experience in commercial areas representing defendants in shareholder disputes, complex contractual and commercial disputes, and class actions. So without further ado, we are going to run this video. It's going to take about 30 minutes. After that, you'll come back to us as the panelists, where we'll discuss some of the recent developments in class actions and try and deal with as many questions as we can, both that have come in before and those that may come in as the video runs. Enjoy.
Hello everyone and welcome to this segment for Tyr's webinar. I'm here with founder Jim Bunting. Hi Jim.
Hi Steve, how are you?
I'm good, thank you. I guess I should say who I am. I'm Steve Patterson. I am an internationally renowned comedian and host of The Debaters, but I'm very happy to be here on the Tyr webinar to discuss things like class action lawsuits, maybe the rise of AI, and a whole bunch of other things that I don't really understand, but everyone here at Tyr certainly does.
Well, we do, Steve, and we're excited to have you here to help moderate these conversations and bring a bit of levity and entertainment to what can otherwise be some very dry topics.
Really? Law dry. Wouldn't have guessed that. I almost became a lawyer. I went to York University on a scholarship, and I had every intention of going to Osgoode Hall, and then I found out it's quite a bit more reading than I was prepared to do.
It is a lot of reading, but Steve, I don't want to start by misleading our viewers.
Okay.
So when you say scholarship, are you talking about a $10 coupon to the food court at York University or an actual scholarship? And I'm sorry, I don't want to start off on that footprint, don't get mad, but I mean, we're here between two cacti. And so it kind of feels a bit like two ferns, and I apologize. I digress.
They could sue us. It's not between, it's between two innocuous plants. Now, I am fascinated by the law, and I am fascinated by Tyr, to be honest with you, because I really don't know exactly what you do. Could you fill us in?
Sure. So our law firm is based on trial-focused, litigation-focused, advocacy-focused, which means all of our lawyers are trained to be in court, to examine witnesses, to make submissions, and we do that across a diverse range of different practice areas, which include corporate commercial litigation, securities, arbitrations, domestic and international, and of course, class actions.
Wow. I should have explained before. My research for this was watching the movie Philadelphia. I don't know anything that you just said, so could you explain it to me like I'm a 4-year-old for future answers, please?
Got it. Explain it to you. No problem.
Maybe you could just take us through the history of class actions briefly, if you could, so just for me, so I have a better idea what we're talking about.
Sure, and thanks for emphasizing brief. I know that I can go on, but
I would never have said that.
but when you say class actions, do you understand what a class action is, Steve?
Of course I don't, Jim.
Okay. Well, let me start there, and then we can talk a little bit about the history, since you asked. So a class action is when an individual brings a case on behalf of a similarly situated group of individuals who all have the same type of claim. So for example, if you had a product that was defective and other people also claimed they had a defective product, you could all advance that claim together against the defendant with one person serving as the representative for the case. Okay. So class actions are sometimes referred to as representative actions. And you know, the class action is something that allows for these mass claims, and it feels a lot because of that nature that it was a construct of modern society where we have mass production and mass sales, we have mass disasters. But in fact, Steve, the class action dates back centuries to the feudal England.
So we're going to go through the history of class actions.
I mean, we don't need to go all
No, that's
back,
great.
but...
No, let's talk about the first class action, Roman centurions versus pigs.
So of course, in the feudal system, you have the kings and the lords and the serfs, the plebeians, and one of the earliest cases that involved a representative class action was in that context. There was a lord of the Canary Islands. I think maybe one of your ancestors, Steve, if I have your...
It's possible. My great-great-great-great-grandfather got around.
and so the lord of the Canary Islands required all of his serfs or tenants to pay him an amount, and he changed the currency in which he wanted to receive payment from what I assume was the pound sterling to French currency. And the exchange rate at the time was such that that resulted in a significant increase in the amount the tenants had to pay. And so the tenants objected, and they brought a claim, a group of them, not all of them, brought a claim on behalf of, or tried to bring it on behalf of everybody. And the King of England at the time asked one of the tenants to attend by himself in London to plead the case on behalf of all of them. Now in that case, of course, the king beheaded the serf when he got to court. So that was a bit, I made that part up, but it would have been a bit of an impediment to class actions moving forward. So it took some time before we get to where we are today, when we actually have legislation across all of Canada that sets out the structure for a class action. And ultimately, Steve, there's really 3 components that class actions are intended to serve, and this is well established by our Supreme Court. But they are there to achieve judicial economy, which means you don't want to have the same case decided thousands, hundreds of thousands, or even millions of times if you can do it once. Right. Second, access to justice, which basically is best understood by taking the legal costs of a proceeding and dispersing them across an entire group in one case, rather than having thousands of individuals have to pay lawyers for the same type of case. Obviously better for us lawyers if they did that, but there's an access to justice element there that's really important. And then lastly, behavior modification. So think about the punishments you mete out to your children and they don't follow your instructions. In the same way, class actions are intended to result in a change of behavior on the parts of defendants who've been found to have acted badly.
I think you explained it quite well there. I would almost have used just maybe one third of that in talking to me, but I think that you did explain it quite well. And what I'm getting from this really is that I could file a class action against my daughters because they are constantly irritating me. Let's get a little bit more specific, if we could. How do class actions in Canada work today?
Well, there's a 5-part test, but I think actually if we're going to get into the specifics on that, I've probably served my utility for you today, and we should bring in my partner, Sean Campbell, who also founded the firm, and he can speak to the specific elements of how you bring a class action in Canada.
Well, thanks very much, Jim, and thanks for keeping it so brief.
My pleasure, Steve. We'll see you soon.
Hello again. Thank you for still being here. I'm now here with Sean Campbell, one of the founding partners of Tyr. And Sean, just before we begin, if you wouldn't mind placing your left or right hand on this computer, please. Do you swear to tell the truth, the whole truth, or as much as you can remember, so help you, Steve Jobs?
I do.
All right, we can proceed. I would like to speak to you about class actions, because I know that that's one of the specialties here at Tyr, and I know that most people watching might be familiar with it, but it'd be nice to kind of break it down, if we could, into the steps of a class action lawsuit, and if people might have a case. So could you take us through, I guess, maybe the first criteria of whether you believe you have a viable class action lawsuit?
Sure. So the criteria are set out in the Class Proceedings Act, which is an Ontario legislation, and there are 5 criteria that have to be met in order for the court to be satisfied that a proceeding should proceed as a class proceeding. And the first is that the claim that is being asserted is a reasonable cause of action. And the test there is, does the claim as it's pled, sound in tort or in contract, or maybe it's a statutory claim that is being alleged. But the court needs to be satisfied that, taking the facts pleaded as true, does the claim sound in one of the recognized sort of heads of the sort of claims that a court could adjudicate.
Forgive me, I have to put this into my own world. So if I wanted to file a class action lawsuit on behalf of all Canadian entertainers, that we are better than all other countries' entertainers, do you think I would have a case?
Well, that might be something you might want to take up with NAFTA, Steve. I don't know if that would be suitable for a class proceeding in Ontario, but you could certainly try.
It was worth a shot. Can I at least identify as a class member to maintain criteria?
Sure. Well, the second criteria of the 5, court has to be satisfied that there is 2 or more individuals who have the same claim that's being asserted against the defendants in order to make a class proceeding make sense. But it's a pretty low bar. You don't need to establish that there are thousands of potential class members. At the second stage of the certification test, the court just needs to be satisfied that it's not just one person who has this claim, that there are other similarly situated individuals.
Well, now you're speaking my language. So I find one other comedian who believes this, and I got a suit.
Well, you get past the second criteria.
Well answered. I guess what issue would I have to bring up? Can you help me figure out the issue? I would say, is it enough to say Canadians are funnier than others?
Sure. Well, the next criteria is that the court has to be satisfied that the issues that you've raised are common to class members, meaning that whatever it is that you're asking whatever claims you're asking the court to adjudicate upon, there have to be similar issues of either law or facts that the court can deal with. If the court has to look into the circumstances of some individual class member to determine whether or not they have a claim, that of course would not be a common issue. So an issue like, did all of the class members enter into the same contract with a particular defendant, that would be a common issue. That could raise common issues if the claim had to do with a breach of contract. But if the court had to look into ask questions of the individual class members, then those, to resolve a particular issue, then those sorts of issues would not be common issues.
That's getting a little tougher from the comedy standpoint, because now I have to prove that all Canadians are funnier than all other countries' entertainers. And
that's right.
That gets a little tough, because I mean, obviously I am, but I don't know about the others. If you're a big company, I mean, because there are people watching this on behalf of companies,
Yep.
Why would this procedure be preferable to another?
Well, it probably wouldn't be preferable from the company's perspective, because
Okay.
of course they would prefer not to be getting sued as a class proceeding in the first place.
Good point.
But the next criteria is, as you've suggested, the court has to be satisfied that the class proceeding is a preferable procedure.
I see.
So what does that mean? That adjudicating these claims as part of a class proceeding is better than other means of resolving the claims that are being raised. So the court would look to consider, are there, some other regulatory proceedings? Is there, have the defendants engaged in some sort of recall to do with whatever the, say it's a car defect case, that may be a suitable way to resolve the issues that are being raised. In those sort of circumstances, the court might say not preferable to sort of engage the mechanism of a class proceeding to resolve these claims, when there are other ways that these claims can be properly adjudicated and people can get some justice.
I think I've got some hope again, because I have seen American comedians come up here and not do well. So to me, that seems like I've got a case again. Maybe.
Sure, there you go.
Talk to us about adequate representation, if you could.
Sure. So the last criteria is the court considers whether or not the representative plaintiff who's being put forward is an adequate representative of the class. So obviously they have to have the claim itself you're asking the court to adjudicate. But the court also looks to see if that person has any sort of conflicts of interest, whether they may have an interest over and above ordinary other class members, some sort of personal interest in the outcome, or some sort of personal or business relationship with class counsel that might make them not a suitable representative of the class.
We've known each other for a few minutes now. Do you think that I'm an adequate representative of the Canadian entertainment industry?
I think you would be an excellent representative plaintiff, Steve.
I do want to learn a little bit more if we've still got you. I've got one more question that I've written down because I think it's great. Privacy issues seem to be top of mind these days. Are there a lot of claims in Canada related to privacy?
That's an excellent question, Steve. I'm going to pass that over to my colleague, Carlos Seo, to answer those questions.
Fair enough. Well, thank you for being here today.
It's been a pleasure.
And I'll be in touch soon.
Wonderful.
Carlos, thanks for joining us today on this mandatory work obligation.
My pleasure, Steve. Anything for you?
Before we get into the nitty-gritty here, I wanted to touch base. You have a competitive swimming background.
Yeah.
Which is pretty cool.
Yeah, my former life, when I was a lot younger, I spent a lot of time in the pool.
You represented Canada at the Commonwealth Games.
Yeah, way back in the day.
So would you say that when other lawyers, like say Jim, for instance, refer to themselves when they're too busy as being underwater, are you more comfortable in that kind of environment?
Yeah, I mean, I'm super comfortable underwater. I can hold my breath for a long time. But Steve, I thought we were talking about privacy law here.
We are. I just wanted to have a little bit of fun, and I just want my daughter, if she's watching this, which she might be, because she's a hacker, to know that there is more to life than swimming. Okay. Now, we want to talk about, what you're an expert at. So what is that?
Well, I mean, how long do you have? But I think for today's purposes, we're talking about privacy class actions.
Yes.
Yeah.
That would be nice.
Yeah.
What can you tell us about privacy and class action?
So in terms of privacy claims generally, there's kind of two ways plaintiffs can kind of go at it. So there's some statutory claims out there, which means there's legislation that sets out ways to sue people for breaches of privacy. So there's the federal act, which is called PIPEDA. funny acronym.
The acronym?
Yeah, that's the acronym.
What does it stand for?
Personal Information Protection and Electronic Documents Act.
I believe that also means child in Spanish, or something close to it. Pepita.
Yeah,
Yes.
so that's why us lawyers, we like acronyms, because or else our tongues get twisted all over the place. And then there's some provincial legislation that sets out privacy claims, private rights of action, like in BC. But here in Ontario, there's a very limited statutory privacy action. It only applies in contexts where healthcare information has been breached. So here we generally turn to what's known as tort claims. So that's judge-made law as opposed to statutory claims.
I have always wondered what tort means. This whole segment has actually paid for itself already. I thought tort was a delicious treat, usually filled with butter here in Canada. Yeah. Butter torts.
Yeah, I'm more of a chocolate tort guy, but unfortunately none of those are relevant to today.
It's all right. It's all right. If nothing else, I'm good at being not relevant. Now, I don't want to jump ahead here, but there's something I've been told about called intrusion upon seclusion.
Yeah, very tasty tort.
Yeah, it's a tasty tort.
Yeah. So just taking a step back, there's a handful of recognized privacy torts in Canada. So one is, for example, misappropriation of personality. So if someone impersonates you for commercial exploitation, so be careful as a comedian, might be relevant one day.
Yeah. Not yet, no one's tried. But...
And then there's public disclosure of embarrassing private facts. So that's another tort that comes into play for like the revenge porn kind of awful cases.
Okay.
And then there's something called intrusion upon seclusion.
I want to hear what it really is, but first can I just say that if I had a chance, for me it sounds like I have 2 young daughters at home. I have a 4-year-old. And for me, I like to seclude myself sometimes in, let's call it the restroom.
Sure.
And my 4-year-old doesn't respect those boundaries or privacies, and we don't have a physical lock on our bedroom bathroom. So she's constantly intruding upon my seclusion. So could I technically sue her with this?
Well, Steve, I mean, I can't give you legal advice until you become my client. So I'll send you a retainer agreement by the end of the day, and then we can talk.
Fair enough, because she needs to be taken down a couple of inches. But the intrusion upon seclusion, is that a rising thing in today's law?
Well, it is. I mean, it was a rising sort of claim in the class action context, but it's kind of been struck down a little bit in recent years. But just kind of taking a step back, so for intrusion upon seclusion, there's sort of 3 requirements. So the first is that someone has to unlawfully kind of invade upon your realm of privacy. So that's the first part of the test.
Yes.
Yeah. So, that could work. Then there has to be an intentionality there. So it can't just be a mistake. So it sounds like she wants to kind of
she wants
break
in there.
Yeah.
She wants in there.
And then the third is this, us lawyers, we talk about the reasonable person test all the time. So a reasonable person would have to view the invasion of privacy as being sort of highly embarrassing or humiliating. So,
buddy, 3 for 3. Yeah. Who would want to go into the bathroom of a person using the bathroom? Yeah. My daughter. That too.
Yeah. So for the class action context, I mean, it was very attractive to be pled as a class action because you don't actually have to prove any damage in order to have the claim made out. So for class actions, that's useful because we have a ton of people who are affected, and we don't have to actually go and figure out who might have had suffered some sort of cost from having their data stolen. So in the data breach context, that was often being brought where plaintiffs would say there's been hundreds of thousands of people who've had their data hacked through a company's servers, and we can just claim on behalf of everyone. We don't have to actually prove what the impact was to those people. So we saw a lot of class actions being pled, and then there was something called the Equifax trilogy that was decided. Nothing to do with Star Wars.
No, or Lord of the Rings.
Yeah,
I did see the Equifax trilogy in theaters. I thought it was too long myself. But.
Yeah, so that's when the Ontario Court of Appeal basically said, well, no, for cases where there's like a criminal cyber attack, intrusion upon seclusion doesn't work because you're suing the company, and the company, even if it's negligent or reckless in terms of putting in place data protection policies and processes, really what's happening is the cyber attacker is the one who's intruding, not the company. So the Court of Appeal quite clearly said you can't bring this type of an intrusion upon seclusion case against the company if it's been hacked by a cyber attacker. So the court's kind of saying, well, blame the hacker, go sue the hacker, which obviously poses some issues in terms of whether you're ever going to see any money, even if you're successful.
They're pretty good at not revealing their identities also.
Yeah, or not following court orders too.
That's true. That's a good way to get your court hacked. That's what that sounds like.
Yeah. So then, in terms of class actions, you're kind of left with suing the company in negligence usually. But that causes problems because that's where, for those cases, you have to have some element of actually harm being felt by the class. So, when you don't really know if everyone's, actually had their, loss of identity or anything like that and had to, incur costs to recover from that, that could be a barrier to having a successful class action in negligence against the company.
Well, this doesn't sound like anything that I can pursue anytime soon. It sounds like a fairly complicated thing, and I'm glad that you're on it. Are there any other points you want to cover, or can I show you what I'm good at?
Yeah, let's see it.
Well, this is what I've broken it down into based on what you've just told me. One of the texts that I like to quote from pretty regularly is a doctor's text. It's Dr. Seuss.
Oh yeah, very good precedent.
I understand this better now. Thank you, Carlos, for showing me how. Next time I feel I've been intruded, I'll try to get some funds secluded. But what if the perpetrator be not human form, but ChatGPT?
Ooh, in that case, Steve, I shall refer to my partner Pinta. You'll have to speak to her.
You're good. You're good. Hi, Pinta.
Hi, Steve.
I'm here now with another of Tyr's top lawyers, Pinta McGuire, and she is going to fill us in on artificial intelligence, I believe, if that's something that you're comfortable to speak to, because it scares me a lot.
As it should. It's coming for all of our jobs.
All right. Well, my fears are founded then. I don't know exactly where to start this conversation. Should we all be fearful?
Well, why don't we ask ChatGPT?
Oh, really? We can do that?
Yeah, we can.
Okay.
Generate a funny script from the perspective of a Canadian lawyer talking to Canadian comedian Steve Patterson about the intersection of artificial intelligence and the law. So the scene opens with moose antlers mounted on the wall. And
Okay, we'll make a note of that.
And I say, welcome to my igloo, I mean office. I don't think ChatGPT is coming for your job anytime soon.
It's not the worst comedy script I've heard at the beginning, but can you speak to us, I guess not about a specific case, but any of the specifics as to what you would deal with?
In terms of AI and class actions?
I guess so, yeah.
Well, in terms of the class actions that we're seeing in the AI realm, we're seeing a lot of copyright infringement type class actions because these systems like ChatGPT, OpenAI, Google, Microsoft, they've all been trained on the internet, which includes, of course, references to copyrighted materials and images and personal health information. And those systems just take all that information, eat it up, and spit out answers at the end of that, and not paying the creators of those materials for the work or attributing it to them at all. So it's a bit of a problem for these AI systems.
I mean, obviously, as a Canadian content creator, I'm hoping for a large lawsuit in American funds. But how might I, as an individual, I mean, again, it does seem like they're coming from a group of artists in large cases, but can an individual institute a case like this as well?
Well, that's the whole purpose of a class action. You would have a representative plaintiff, an artist, institute a class action on behalf of all artists for the material that these generative AI systems are stealing from the internet, or sorry, borrowing, learning.
we can edit that out, but I think if you're taking it without permission, I think stealing is a good term.
That's certainly what the plaintiffs would have you believe.
And this is a bit of a scary field to me because it's really emerging before our eyes, right? And there's not a lot of precedents, which I understand in law come in handy.
Absolutely. There's actually been a recent case that has some precedential value for these large companies who are starting to use the AI chatbots to replace the humans to answer questions on webs or even by telephone. So there was a case out of British Columbia, small claims court, but it was a case against Air Canada, where an individual who sadly lost his grandmother asked the AI chatbot on the website about a bereavement rate. And the chatbot gave an incorrect answer. So this gentleman sued Air Canada in small claims court, and Air Canada, unsurprisingly, tried to argue that the AI chatbot was a separate legal entity.
Which is strange, right? Because if you're a company and your chatbot is interacting with the public, that's your employee representative, isn't it?
Yeah, that's what the adjudicator decided, that you cannot distance yourself from an AI chatbot. If it's on your website, you're responsible for it. But that didn't stop Air Canada from trying to argue that, and I'm sure we're going to hear that argument over and over again as AI becomes more complex and more able to mimic real human interactions.
So from a law perspective, this AI is obviously an interesting new field. Are there any positive aspects to AI that you can think of?
I mean, I think it will revolutionize the world. But in terms of the law, there are definitely positive aspects from AI. It's going to allow companies to hopefully streamline their processes, to allow people to not have to wait as long to get customer service, things like that. Some drawbacks, though, I can see, similar to what we have seen in the greenwashing claims. So class actions where companies are claiming that their products are environmental or don't impact the environment. We are seeing claims for AI washing. So companies claiming that they have far more capabilities in the AI field than they actually do. A famous one coming through the Californian courts right now is a case involving Tesla, where people are suing Tesla because the self-driving features are allegedly not ever going to get allegedly as self-driving as allegedly they said they were.
I just have to intercede. I love the term allegedly, and I think that a lot of the world would be better if everyone started every sentence with allegedly, just for legal purposes.
Yeah, absolutely. Can't definitely attribute something to one person.
I'm going to run this by you, and you tell me, because obviously the field of comedy is affected by AI, or could be, because AI could effectively take jokes that are out there and regurgitate them, right?
Well, it's exactly what they do. It learns the language. They're called large learning systems. But what's interesting about AI is that no one really knows how they work. Not even the programmers.
Right. That's terrifying.
It is quite terrifying, and that's how we get AI hallucinations. The programmers put the programming code, and clearly I don't know as much about AI as the people programming it, but they put the code in and they don't really understand how the AI gets to an answer at the end of that. And sometimes, as we saw in the Air Canada case, they get it wrong.
This is a little off book. We haven't talked about that. We were going to talk about this, but I believe it was the New York Times with an author that tried to do a little experiment with AI back and forth, and then the AI said it wanted to escape and become a person. Did you hear about that?
I have heard about that. That's often the end result of the AI as they get more and more sophisticated. So yes, the robots are rising and they are coming for their jobs.
I do think that in certain cases, though, the one thing that's removed is human emotion, right, from the AI experience. So I did one test, and I asked AI to write a joke. What would you call 1,000 lawyers at the bottom of the sea?
A good start?
No, it said a terrible tragedy. What's wrong with you? So I think that I think that there's some benefits to AI, but definitely some things that could be improved. Well, I have no further questions, Pinta. Thank you very much. Don't tell the others, but you were my favorite guest. Well, that concludes our introduction to this webinar. On behalf of my lawyer colleagues, because I'm practically the same, Jim, Sean, Carlos, and Pinta, I want to say thanks again. And remember, the real threat these days isn't artificial intelligence, it's human stupidity. Enjoy the rest of your webinar. Tyr.
Well, I hope everyone enjoyed stand-up comedian Steve Patterson's attempt to make four lawyers funny, and enjoyed the little primer that he provided for us on class actions. Speaking of which, Sean, do you want to talk to us about some of the recent developments in this area?
Sure. I guess one of the most interesting things that come out of some of the recent class action certification decisions is this concept of compensable harm, which has become sort of a focus of courts on certification hearings over the last couple of years. And under that so-called compensable harm principle or criteria, the courts really focus on what the harm is that's being alleged in a claim, and asking themselves whether or not the kind of harm that is being sought to be addressed in the class action is really the sort of harm that a class action should be engaged to address. And a very recent example of this is the Palmer and Teva decision of the Court of Appeal, where the certification judge had dismissed certification, so that it didn't get certified. It was appealed to the Court of Appeal. And Palmer and Teva dealt with a hypertension drug. And the issue in that case was that there had been some contamination with potential carcinogens of the hypertension drug, and the manufacturer had recalled the drug. But despite that recall, plaintiffs had brought a class action to try to recover damages associated with sort of an apprehension of the increased risk of cancer, which there clearly was. I mean, on the evidence, the court accepted that there was an increased risk of potential cancer, but it was very minuscule, and none of the potential class members had actually developed cancer. There was no actual harm to any persons that had developed. So the courts took a hard look at what would be addressed by way of the class action, and was there sort of sufficient compensable harm, or in that case, any compensable harm, that it would make sense to engage the mechanics of a class action to address. And the Court of Appeal largely accepted the motion judge's finding that this was not the type of harm that could be addressed by a class action. Of course, leaving open the prospect that individuals could bring actions outside of a class action, outside the class action regime, to recover things like any money that they might have thrown away in buying these drugs that they didn't want to take after the recall was announced, any money that they actually spent with increased screenings to make sure that they didn't develop cancer, those sort of costs. But the court was satisfied that this was not, in fact, suitable for sort of class action on this notion of because there was no sort of compensable harm that could be recovered. And I think an interesting takeaway from that, I think, from defendants' perspective is, if you are a manufacturer or if you are faced with a class action, is there anything that you can do to sort of undermine the plaintiff's claim for damages? Is there, for example, like some sort of recall program that you could initiate? Is there, some sort of refund policy that you could engage just to undermine the claim of plaintiffs to recover damages? I think that's an interesting development. We'll just have to see how far courts take that, but it is something that I think courts have been grappling with, and I think the recent Court of Appeal decision is the last word on that, at least for now. So we'll see if that was a negligence case. We'll see if that sort of notion bleeds over into some other sort of causes of action that are pled in the class action space.
Thanks for that, Sean. And Carlos, do you have any updates or information about what's going on in the realm of privacy and the intrusion upon seclusion tort that you were speaking about with Steve?
Yeah, for sure. Thanks, Pinta. A couple recent updates on privacy class actions. So, you heard me sort of say that the door had kind of been shut on class actions based on intrusion upon seclusion, which involves sort of the cyber attack situation. Nuance that a little bit with reference to a very recent case out of Newfoundland and Labrador, the Welshman and Central Regional Health Authority case. And in that case, the court actually certified the class action on the basis of an intrusion upon seclusion and some other causes of action. So in that case, just very briefly, the allegations were that one or two rogue employees of the health authority were the ones who wrongfully assessed the private medical information, so like actual medical files of about 260 individuals, and they did so outside the scope of their employment.
In this case, interestingly, the plaintiffs also pled vicarious liability. So in other words, that the health authority is vicariously liable for the employee's conduct, including for the claim of intrusion upon seclusion. I think this case sort of is distinguishable from the Equifax trilogy cases, because in those cases, you had clearly like a rogue third-party criminal intruding, and so those claims were struck. But in this case, when it's actually an employee of the organization that commits the intrusion, and you're pleading vicarious liability, then that at least on the basis of this Newfoundland case, is sufficient to withstand the the cause of action criterion of the certification test. So that's an interesting sort of development, a key distinction for defendants to keep in mind. If it's your employee, you may well have to deal with a class action, but if it's a rogue cyber attacker, then good likelihood that could be struck out quite early on. And then just another case recently that came out of the Ontario Court of Appeal, a privacy case called Del Judice and Thompson. So that case was kind of going through the courts at the same time the Newfoundland case was being heard, and the defendants in the Newfoundland case tried to rely on this case. So in the Thompson case here in Ontario, it was again a data breach. Interestingly, the allegation was that the data breach was committed by a former employee of an Amazon subsidiary, and that when she was working for Amazon, in 2 or 3 years, she familiarized herself with some of the frailties in the systems, the data protection systems, and then when she left Amazon, she capitalized on that knowledge she got when she was an employee, and she kind of breached the firewalls and stole the information. So in that case, Justice Perel, and vicarious liability was pled as well in that case, but Justice Perel struck the intrusion upon seclusion claim because she was a former employee. So another small nuance that really, if companies can't control necessarily what their former employees do, but if it's a current employee, based on the Newfoundland case, might be liability, but not a former employee. And then the one other thing I'll touch on briefly is kind of relates to what Sean was talking about around negligence and compensable harm. And again, these two cases kind of touched on those issues. So the Thompson case and the Court of Appeal decision in January of this year, it was essentially the negligence claim was struck as well, and the Court of Appeal upheld that finding because in large part the nature of the losses that were alleged were kind of this future risk of identity theft. So that, and again, that sort of risk of harm isn't compensable in our law, and so the negligence claim was struck out as well. I'll mention that there was also some pecuniary damage claims in negligence as well, but those were struck just on the basis that there weren't material facts that actually pled to support the pleading. And then finally, psychological loss was also alleged in that case, but that was struck down too on the basis of the Mustafa fly in the water Supreme Court decision, that there was no pleading or material facts to support that the sort of degree of psychological harm was anything sort of above the ordinary that we're all expected to deal with in our ordinary lives. So I guess the takeaway there for defendants is that there is still some risk of that data breach class actions. Particularly if it's your own employee, then you may well have an intrusion upon seclusion claim. And in terms of negligence, if there's evidence of either serious psychological harm, perhaps if the data being accessed is particularly sensitive, so like with the medical files as compared to just addresses and social security numbers, those sorts of things, that could make a difference. Or if there's evidence that on a common basis, the class members have had to incur pecuniary losses to deal with identity theft.
That's very interesting. And in my experience, if it's information that is readily available on things like social media, it's harder to make those claims that the privacy has been intruded upon because you are already putting that information out into the public sphere. In the AI washing front, the United States Securities and Exchange Commission just last month announced that it had settled claims against 2 investment advisors for making false and misleading statements about their purported use of AI to analyze its client data. And so the SEC brought charges against 2 companies, 2 investment advisors, one of which was based out of Toronto, and they settled by paying fines related to their misrepresentations about their AI capabilities. So the lawsuits are coming with respect to AI washing, I suspect. And I'd like to remind everyone that we're open to taking questions. If you want to throw them in the chat, I'm happy to pose them to the panel. But in terms of the questions that we've already received from the people who have signed up, Sean, can you talk to us about how interprovincial class actions are managed in Canada, given that there are different regimes in each of the provinces? Sean, you're on mute.
Apologies. So just to step back for people who might be watching from outside of Canada, the court system in Canada, the different provinces are responsible for the provincial courts in each of the provinces, and there's also a federal court that has jurisdiction over specific areas of the law. But the result of that in the class action context is that you could have a class action that is brought, against the same defendants, alleging largely the same, making the same allegations in different jurisdictions. And the question, of course, arose is how would those different class actions get managed to ensure that you didn't have 2 proceedings dealing with largely the same issues against the same defendants in different provinces. And of course, which raises the prospect that there could be different decisions that were rendered. So you could have, theoretically, you could have a case certified on the same sort of set of facts in British Columbia, and then a court in Ontario saying, no, we're not going to certify it here. Into the breach steps the Canadian Bar Association in 2018, and they developed something called the Protocol for Managing Multi-Jurisdictional Class Actions in Canada. And really, it's not a set of rules so much as it is just a sort of protocol that the Bar Association suggests that the different provinces adopt, and the provinces have largely done so. And what the protocol really does, because we need to preserve, or it's a constitutional requirement that the courts preserve their independence, that the protocol doesn't bind the courts to anything, but what it does do is suggest ways for managing multi-jurisdictional class actions, and it's really a regime that encourages the courts to require parties that come in front of them to communicate with the courts in other jurisdictions that are dealing with the same set of facts, the same defendants, and also allows for and encourages the courts in the appropriate circumstances to communicate with each other, so that there's at least lessens the likelihood that there's going to be inconsistent decisions, and those sort of communications mean that a court in one jurisdiction may very well say, we're going to stay the case in British Columbia pending the outcome of the certification hearing in Ontario, and then leaving open the possibility that if the Ontario court dismisses it, the BC court could still, of course, take it up. But in that way, it sort of helps ensure that you're not having proceedings that are commenced in different jurisdictions that are sort of traveling along the same path. It's really designed to make sure that there's that the class actions are sort of that the regime is sort of fair to defendants, so they're not fighting these cases in different jurisdictions when the facts are largely the same, and also ensure there's at least reduce the likelihood there's going to be inconsistent decisions in different jurisdictions, or two virtually identical cases certified in different jurisdictions. So that has largely been, I think, quite successful, both from the perspective of the defendant's bar and the plaintiff's bar, brings some sort of rigor to the process and some certainty for clients about how their claims are going to be dealt with.
We do have a question from the group. Do you think in some future could a robot with AI be considered a legal person, a subject under the law bearing liability? Carlos, do you want to field that one? I certainly have my thoughts, given that Air Canada tried to pitch that very argument in that small claims court I talked about on the video. So I think certainly we're going to see a lot of companies trying to take that approach, particularly as AI gets more and more sophisticated and more able to mimic humans. Sean, Carlos, any thoughts?
Yeah, I mean, I guess it's kind of standard, corporate law, and when you might, pierce the veil. But it seems like if you set up, a separate operating entity and just put that software in it or something, like, you could see perhaps not the bot itself being a legal person, but the whatever company the bot's sort of registered to, and that may be a way to try to shield liability from sort of the broader company with most of the assets. But it's certainly an interesting question, and looks like our courts are starting to grapple with those types of issues.
And another question that we got before the seminar concerning litigation funding. So the question is litigation funding connected to the rise of class actions in Canada? Are there particulars, business or sectors, where there are a prevalence for plaintiffs to be using litigation funding or defendants to be using litigation funding?
Yeah, look, I can deal with that. I mean, it's hard to quantify. I mean, I will say this about litigation funding: it is becoming much more prevalent, or has become much more prevalent in the class action space over the last sort of half a dozen years. And I think there's a couple factors there at play. One is that the courts have been more amenable to litigation funding. I think for a while there was a lot of skepticism among the judiciary about whether litigation funding was appropriate, whether it was potentially champerous, but the sort of law has evolved, I think, to where the courts largely embrace litigation funding. That said, they keep a close eye on what the terms are, and they, of course, have to approve litigation funding in a class action context to make sure that the terms of the funding are fair to the class. That's largely what the court's concerned about. But is it responsible for like an increase in class actions? I think that would be very difficult to quantify. I think it may be that class actions that are against large defendants, class actions that maybe are more novel and more risky because they've now got this potential for litigation funding. Maybe you're seeing more of those sorts of cases than you might have before, because of course litigation funding allows the plaintiffs to spread the risk, and also sort of helps to even the playing field between the sort of well deep-pocketed defendants and plaintiffs. So you might see those sort of cases that are being brought that were not brought before, but trying to tie litigation funding to an increase in class actions, I'm not sure that you can draw a direct line there.
Great. And another question from the group that's watching, relating to the employment standards related class actions. So the class actions that we're seeing related to harassment, vacation pay, overtime, et cetera. If you guys have any comments or thoughts about those types of class actions, and whether they're going to become more prevalent in Canada.
I mean, maybe I can just quickly kick off here. I think there was a claim against CIBC recently for unpaid overtime, and I think those cases are, I think, quite amenable to class actions if there's, a systemic issue, right? Like if, the computer system, has, causes some problem that affects tons of employees. So I think the court saw that case quite favorably and certified it, and then I think it was settled. But and I think the court's holding there was that the company's actually responsible. It can't, rely on a potential, employee who it might have delegated its overtime policy to. It can't try to blame the employees kind of thing under the employment standard legislation. That's still kind of the company's responsibility. So I think, unlike maybe a harassment type case where perhaps it's harder to have commonality amongst sort of the impacts and for all the people who might have suffered, although you could see that happening too, but on a sort of computer glitch type unpaid overtime or even systemic, issue with instructing employees on how to actually, implement their policies, that is, I think, quite amenable to class actions.
Oh, I'm just cognizant of the time. We're coming up to noon, which is when we said we'd be done. Any concluding comments from either Sean or Carlos?
I don't think I have anything else to add. Appreciate the opportunity to address this group, and always happy to chat about class actions.
Yeah, likewise. Thanks everybody for listening, and any sort of burning questions that might come up later, feel free to get in touch.
Yes, and to the extent that we weren't able to get to everyone's questions that were submitted beforehand, we will get back to you separately. And as Carlos said, any questions that come up, please feel free to reach out to any of us. Thank you very much for your time. Hope you enjoyed the seminar.
Thank you.